I welcome you all to the fourth seminar of the International PhD in Progress seminar series. We're currently in phase 4, and this series is organized by the Global South Network. I'd like to start the session by thanking my colleague, Dr. Norman Rayat, who's in the session. He's a lecturer in law at the Leicester Law School, and he's also the founder and convener of this network, the Global South Network. My name is Dr. Beth Kamunge-Podo. I'm also a lecturer at the University of Leicester School of Law, and I've also been called to the bar in Kenya. My key research interests are in global health justice, international environmental law, and human rights. I will be the chair of today's session. Today we are expecting 2 discussants. I think our first discussant might still be on the way. So I'll introduce them and they'll join us when they are able to be here. So our first discussant is Professor Adebambo Adewopo. Professor Adewopo is a professor of intellectual property law at the Nigerian Institute of Advanced Legal Studies. Professor Adewopo is also a senior advocate of Nigeria, a rank which was conferred to him in 2017. He brings on board almost 3 decades of academic, private, and public sector experience since he scored the bar in 1989. In 2004, Professor Adewopo was appointed to be the Director General of Nigerian Copyright Commission and held the position until 2010. In his capacity as the Director General, he headed several delegations of the government of Nigeria to the meetings of the Standing Committee on Copyright and Related Rights, and member as well as several delegations of the government to the Diplomatic Conference, Geneva, amongst others. Professor Adewopo is a fellow of Salzburg Seminar, Max Planck Institute for Competition and Intellectual Property, Germany, and Center for Studies in Intellectual Property and Information Technology Law in University of Edinburgh, United Kingdom. He has written over 100 published works, including articles in peer-reviewed journals, book contributions, and authored books on copyright and IP law. Professor Adewopo has also delivered over 100 conference papers. Professor Adewopo is nominated by the federal government as a Nigerian candidate for the post of Director General of the World Intellectual Property Organization. So he's very welcome, and like I say, he will join us as we carry on. Our second discussant, who I can see on the call, is Dr. Eleojo Aishatu Adaji. Dr. Adaji is a lecturer in the Department of Public and International Law, College of Law, Osun State University, Nigeria. She is a member of the Nigerian Bar Association and the Institute of Chartered Secretaries and Administrators, Nigeria. Dr. Adaji's scholarly engagements focus on intellectual property law and information technology law. Her current research focuses on the interaction between intellectual property rights, data privacy, open science, and genomic and health research in Africa. You're very welcome, Dr. Adaji. Thank you so much for joining us. We will also be joined by Gabriele Cifrodeli, who is a peer commentator for today's session. Gabriele joined the School of Law and Create as a PhD candidate and he's also a research and teaching assistant. He joined the school in September 2022. Gabriel's research interests mostly lie in the intersection of intellectual property, technology, and open innovation. And currently, his focus, which is what he's doing as part of his PhD project, is on the application and testing of governing knowledge commons framework in AI-powered drug discovery and development. He is the convener of the Intellectual Property Reading Group in CREATE and a coordinating board member of Scotland. Previously, his LLM dissertation, Patent System and Artificial Intelligence Towards a New Concept of Inventorship, has been awarded as one of the outstanding LLM dissertations by the School of Law in the University of Glasgow in 2021. Gabriele is also a law graduate from the University of Trento, where his dissertation, Can You Patent the Sun? The COVID Vaccine as a Chance to Rethink the Relationship Between Intellectual Property and Commons, has been recognized as one of the outstanding dissertations in the open science field written in the years 2020 to 2021 and 2022. So we will welcome him. He's also joining us. Last but not least is our guest speaker for today's session, Isioma Ewelukwa, who is currently in her third year of a PhD in intellectual property law at the University of Leicester Law School. She has a master's degree in corporate law from the University College London and a bachelor's degree from River State University. She's also an assistant chief law research officer at the Nigerian Law Reform Commission, where she has worked for the past 11 years researching on and proposing reform for different laws in Nigeria. She has research interests in intellectual property law and regulation, anti-corruption law, and legal reform in Africa. She has published articles on anti-corruption laws and legal reform in the Nigerian Law Reform journals, and has also advocated for the passage of several laws on anti-corruption in Nigeria. She played a key role in the advocacy and eventual passage of the Discrimination Against Persons with Disabilities Prohibition Act 2018 in Nigeria. You're very welcome, Isioma. Today, Isioma will present her project, which is titled Local Pharmaceutical Innovations versus International Patent Obligations, the Nigerian Dilemma. So after Isioma's presentation, I will then give each discussant some time to give their remarks for about 5 to 7 minutes each. Then I will also take one question from the floor before then inviting our peer discussant also to speak for 5 minutes. And Isioma will also have a chance to respond to the comments and to the questions before I conclude the session at 4 p.m. Please make sure to, please feel free to make constructive comments on the chat or ask questions on the chat as the session progresses. And also please keep your mics off during the session unless you're speaking. Thank you so much, and Isioma, the floor is now yours. Thank you.
Thank you so much. First of all, I just would like to say thank you to the conveners of this platform. I'm just so honored and grateful to be here and get this opportunity to actually present my work. I was just, like I was explaining to Dr. Norman earlier, just when I saw the panel of those and the caliber of people that will be on it as that are here as discussants, I felt so honored and privileged to have such persons here on this panel. So I would like to express my deep appreciation to Dr. Norman for reaching out to me to present my work here. And well, I would try to go right into it because I do not want to take too much of our time. I would like to give enough opportunity to the discussants and other panelists to actually bear in on the work. So permit me to go right into the presentation. And for the sake of time, I'll see if I can, maybe browse through the introductory slides so that we can get into the meat of the work. And also, so if there's any maybe any questions from those introductory sides that I'll be rushing through, please feel free to put it in the chat and I can still go back to it. So the title of my presentation today is Local Pharmaceutical Innovation versus International Patent Obligations, the Nigerian Dilemma. Please, next slide, please. So as a way of introduction, like we all know how important pharmaceuticals are in public health generally, and particularly in Nigeria, pharmaceuticals are important to both treat diseases, contain epidemics and outbreaks. So they are very important. We all know about that. And particularly for the Nigerian situation, Nigeria relies, being a developing country, there's a lot of reliance on imports for pharmaceuticals, which, as we know, is not a sustainable position. It's not a sustainable way for a nation to be, because there's, having to rely on aids, it's not something that we will want to do for a long time. And then getting to the TRIPS agreement, which is the Agreement on Trade-Related Aspects of Intellectual Property Rights. We all know it's an international law, one of that groundbreaking international law that was introduced in the intellectual property space, and it's something that came in to bring that uniformity in intellectual property regulation in 1994. And when it came in on the backdrop that introducing it would encourage local innovation and investment in the pharmaceutical sector. So there was just a lot of, prospects about it, especially in relation to a developing country like Nigeria, being, encouraging innovation and then boosting investments and all of that, technology transfer. So these were some of the things that, surrounded the introduction of the TRIPS agreement. So next slide, please. So based on that, there was a lot of talk about the TRIPS agreement aiding, encouraging innovation. Since it has done that in the global south, it's found, there will be a lot of technology transfer. There was a lot of that. But over the years, we have come to see that hasn't quite been the case. The local innovation that was really hoped it was supposed to bring about we have not really experienced that, particularly in Nigeria. So, but now with what is going on now, Nigeria is a signatory to the TRIPS agreement. So we have that duty or that obligation to comply with the international agreement. However, on the other hand, there's this argument that it may actually not, in fact, even be discouraging local innovation rather than encouraging, particularly when we have examples like Brazil, where they suspended patent rights, and that was actually what helped them, what boosted local innovation. So it was, you now have this, okay, does it actually boost local innovation, or does waiving it or setting it aside actually boost innovation? So we're now saying, does it have the opposite effect, or, is it the other way around? So there's now this problem or this dilemma now, that, okay, having to comply with TRIPS agreements, is it actually stifling local innovation, or is it promoting, so that is really the dilemma I would say that Nigeria is now in. So here we have, okay, patents encourage. So yes, we have that idea that yes, patents encourage local innovation, encourage innovation in general. Yes, it does. We all agree about that. Although yes, there's some arguments against that it doesn't actually, encourage innovation, but it has the capacity to do that. So that is accepted. But on the other hand, we also have this issue of, okay, Nigeria being a developing country, we don't have a local pharmaceutical industry yet. So when you have foreign pharmaceutical companies registering their patents and then holding that monopoly right for extended periods like 20 years, it now makes the local innovators, before they are able to come into that space, you now have them holding that monopoly rights for this extended time by virtue of the TRIPS agreement. So that now brings that conflict, you know. So can we go to the next slide quickly, please? So this research now, I'm now looking into, okay, we have this problem, we have this dilemma, but we are not going to sit back and say, okay, since this is the situation, our hands are tied, we can't do anything, we have to just stay, because really that has been the perspective even before I came in to start this research. You know, when I was speaking to some people, some key people in Nigeria, they said, oh, why are you doing patents? We don't need it. I mean, it's not helping us, you know, especially those who feel, okay, patents are more, you know, foreign laws, they don't help us, so let's set it aside, you know. So but my view has been, okay, no, we need to find a way to make it work. Instead of saying it doesn't work, we need to find a way to make it work within the framework, within what we have, or the limits that we have available. Are we fully maximizing it? So the significance of this is that being able to find a way to creatively adapt our local laws so that they can actually boost local innovation is significant. Which is what is the goal of this research. It's significant in that it's a sustainable solution to the access problem. So when we talk about access to pharmaceuticals, most people talk about, okay, the TRIPS agreement, the TRIPS flexibilities. We have all these international solutions, I would say, to the problem, or proposals as solutions. But what we really need is how to boost our local innovation. That is what we really need in terms of when we're looking at something sustainable. We don't want, you know, something like temporary solutions, things that, okay, we want more access that will allow us more access to these pharmaceuticals for now. Well, how about in the future? How about, because we need to boost in our local innovation, our local pharmaceutical capacity is beneficial in the long run, you know, and not just in the short run. So that's the significance of this. And then, of course, it would also improve overall public health, bring about economic growth and development. It will minimize reliance on foreign aid, which is what we are looking for, and it will promote R&D in treatment or containment of local diseases. So because we have these pharmaceutical companies securing patents or monopoly in Nigeria, we buy these expensive drugs. We have to buy them at an expensive rate because of the patents on them. And then that's the profits that are gotten from that sale are used by, are now taken by these foreign pharmaceutical companies and used to invest in research and development in foreign diseases, as against diseases that actually apply to us Africans or Nigerians. So the significance of reforming our laws so that they can actually boost local innovation is so that these local inventors will be able to do R&D in diseases that actually apply to Nigerians. So I'm just trying to make us understand how important this is. So we also have examples for other developing countries. So it would also set as an example, because Nigeria is of course not the only developing country that has this dilemma, that is facing this dilemma. So using the results of this research would also be useful for other countries that are facing similar situations. Can we move, please? Next slide, please. So regarding the gap in the literature, so like I said earlier, most of what has been proposed are more of external solutions. They will say, okay, we should use the TRIPS flexibilities, use other approaches say, okay, it's because of, TWIL, the third world application of international law and all that. The other argument that, sorry, excuse me. Okay, so the argument that, look, these laws are foreign and that's why they are not very efficient or effective in Nigeria and all of that. That is what the argument that has really populated that space. So, and I also referred to the writings of people like Dr. Amaka, Professor Adeopo, who I have the privilege of presenting to today, and so many great writers out there have spoken extensively on the issue, but most of the time we have those, like I said, external solutions or external arguments, and which are also very important and very essential. But what this work is trying to focus on is what are those internal reforms that can actually be done that can help us to maximize these external solutions. Because and I think this perspective also came about from my looking into some other countries like Kenya. They were able to look internally and say, okay, we are in this situation, but what can we do within our laws, within our legal framework, to actually maximize the opportunities that we have? Norman, I think the slides you're using are the old slide, but so because I think it's not the correct one I gave you. I'm sorry. So it's a bit different. Okay, but I think we can keep going. I'll just okay, can you go on more, please? Can you go forward more, please? Okay, so yeah, no, yeah, this is fine. So my argument now is, yes, indeed, Nigeria adhering to these international patent obligations, it actually could undermine its ability to stimulate local pharmaceutical innovation and creating a public health vulnerability during crisis. So now, in my thesis, I'm not contesting that. I'm saying, okay, yes, it is true that it can actually undermine the ability of local innovators or local scientists or to thrive, or to thrive. But however, my core argument is that even within that within what we have available, this framework that we have available, there's actually scope to actually reform the internal regulatory framework to maximize and to encourage local innovation, even in spite of these challenges that I've just explained earlier. So, and I said here, note Kenya, and the reason why I'm noting Kenya is because I saw an example of how Kenya was able to, because they were doing this research, they were getting a breakthrough in a research on HIV, on a HIV drug, and they looked at their laws and saw how the patent law could actually, be constrain them from maximizing this innovation. So they were able to reform their law. They set up a committee and reform their law to still, take advantage of the flexibilities and still make it work for them. So looking at that, example, I was saying, okay, hey, Nigeria, we can do similar thing. We've not actually looked inwards. Have we fully, maximized what we have available to actually help us boost local innovation? So that is my argument, that there is actually a scope for reform of our internal regulatory framework to improve access and also boost local innovation while still being in compliance with international obligations. Next slide, please. Okay, so for this research, I'm using the doctrinal analysis and doctrinal method. So I'll be analyzing legal instruments, the TRIPS agreements, Nigerian intellectual property laws, particularly the Patents Act, other laws like competition laws, and how they also can be reformed, as well as regional policy documents, the AFCFTA, and institutional framework as well. Please go on. Okay, so regards to the challenges, like I expressed or mentioned, the duration of patent protection has been an issue, or it can be a constraint, because that's the pharmaceutical companies holding monopoly rights for that extended, or the longer they're able to hold those rights, the farther away it is for local innovators to get into that space. So you actually, that's extended period of patent protection actually doesn't give the local innovators the opportunity to come in to that space. And then I also talked about the challenge of patent evergreening, which is how how companies can creatively, extend the period of their patent by maybe they would, just introduce minor innovations and then reapply just to find a way to extend the period of their protection. And then we also have political will to introduce or implement needed reforms in local laws. That's the challenge, because in Nigeria, we've been trying, our act is decades old now, because it was passed in 1970. But up till now, we've had times and there has been efforts to actually reform the law, but nothing has been successful till now. So we have that challenge of political will to make that needed change. And then we also have external forces, of course, like maybe influence from like the USTR list is also something that has been a major influence, causing countries to not want to use things like the compulsory licenses and all of that. So we also have that international politics that is there, countries not wanting to use flexibilities for fear of being, blacklisted and things like that. Then we have the challenge of corruption, which of course, like we all know, is quite endemic in Nigeria. And then we have others, which is electricity and infrastructure, because when you're talking about technology transfer, if we don't have the infrastructure or the electricity and all of that, or the framework to receive the transfer technology, then it's impossible, it's a waste, and which has been actually what the pharmaceutical companies have been using to say, okay, this is why we can't locally produce, this is why we can't transfer, because we don't have the infrastructure, we don't have the capacity and things like that. So those are the challenges. And then funding, of course, is another challenge that we've been facing. Next slide, please. To keep it to time. Okay, so the proposed solutions, which from the study. So just 1 minute. Okay, so the first, we're talking about amending national IP laws, which I've already said. So I'm looking at the Patent Act itself, to see what are those areas that can actually be reformed, that can actually help us in terms of local innovation. So we have issues like parallel importation, which in the Act currently is not very clear. And even the option that is being chosen, we have to reevaluate whether or not it's actually beneficial for local innovation. And then issues like technology transfer, what are those things that are inhibiting technology transfer, and what can we do within our laws that can aid technology transfer. Then we have substantive examination of patents, which has been a major issue with our law, and we need to look into how that can be changed. Then we're talking about strengthening R&D funding. So a lot of the excuses that has been raised, okay, we cannot, there's lack of funding for R&D. But what Kenya did, which I thought was instructive, was that they said, okay, since this Patent Act or patent registry, for instance, we're registering patents for these foreign companies, and it's not particularly benefiting us locally. How about we increase the licensing fees so that the registry office is being self-funded? Let the foreign companies, let them be the ones funding that registry, so that we don't have to use our own public funds, to be funding a system that does not benefit us. So that kind of creative, readaptation is what I'm looking at, in terms of how we can, because that example, for instance, is still in line with the TRIPS agreement. They're not flouting any international obligation or anything like that, but yet they are still, creatively saying, okay, this is how we're going to maximize this situation. So another thing is investing in scientific training, of course, and infrastructure. I looked at NOTAP, which is the Office for Technology Acquisition and Promotion. So these are all institutions that have been set up to boost local innovation. So I'll be looking at their framework and how that can also, how we can, because sometimes these patents, the way it is in Nigeria, is sort of like on its own. It hasn't been integrated into the different institutions that can actually help to boost local innovation. So I want to look at how that can be be changed, you know. And then we now have integrating patent framework into health. Yes, this is another very good solution. I discussed, it was actually Dr. Makavani that shared this idea with me, and I thought it was really, really something to explore, because she was explaining that, look, Nigeria, when you talk about, you know, access and TRIPS agreement and everything, it's or maybe containing diseases in Africa and in Nigeria's case, it's not all negative. Like we have the case of the Ebola crisis. You know, this is a case that was celebrated. Nigeria was celebrated for having contained it so fast, and you know, the way the Ministry of Health and things worked, it was really surprising, you know, to the world, you know, at the way it was handled so quickly. So that tells us that something is actually working. So it's not everything that is not working. So how can we get the patent system to be sort of like ingrained into that system that is working? You know, like we said, okay, the Ministry of Health, and they were able to contain it. They were able to set up structures that contain the Ebola crisis. Is there a way for us to situate patents within that framework to see if, okay, those systems can take advantage of the patents to boost local innovation in the pharmaceutical sector? So she brought up that idea, and I've also been trying to think about it, because currently now, when it comes to compulsory licenses, it's the Minister of Commerce that is empowered to issue compulsory licenses. So I'm thinking, okay, how about empowering the Minister of Health to issue compulsory licenses? Because the Minister of Commerce does not know the gaps in the pharmaceutical sector. It's the Minister of Health that will know what are the gaps, where do we need to employ compulsory licenses to fix some gaps. It's the Minister of Health that would know that. So if the Patent Act can empower the Minister of Health rather than Commerce to issue compulsory licenses, then probably it will be more utilized, because right now the government has not issued compulsory licenses for anything, you know. So, you know, thinking about how we can actually put patents into where it's working, so to speak, you know, and see if that would actually boost local innovation in that area. That's what one of the things I'll be exploring as well. So, and then also looking at ways to maximize African regional alliances. So we have the ARIPO, we have the, you know, the AFCTA and other, you know, regional policies and bodies that Nigeria could actually use or leverage on to increase, you know, local innovation. You know, also things like, because we're talking about substantive examination of patents, and you know, one of the arguments has been that it's too expensive. But if Nigeria can leverage on those other, you know, external regional alliances, it can actually get to still do substantive examination of patents in a more, you know, efficient way, you know, cost-effective way. So those are the things that I'll be exploring in because of the work. Okay, please go on.
Excuse me, please, Isioma. Thank you so much. Please, if you could try and wrap up in the next 2 minutes. Thank you.
Yeah. I'm actually in my concluding, I think. I'm actually in the last slide, is it? Yeah, I'm on the last slide. Okay, so basically, in conclusion, Nigeria must balance patent obligations with public health priorities. This is just like we have said. So, in as much as we have to meet up with these obligations, we also have to prioritize public health and ensure that this works. We make it work for us, basically. And then a proactive policy framework can drive pharmaceutical innovation while respecting international agreements. So this is really the focus of my work and what I intend to draw out, that actually we can make this work for us. And what are those internal things that we can do, reforms that we can do that can actually, you know, make it work for us. So hopefully, I hope that it will be a profitable exercise, you know, and I would appreciate all your views and your comments. Next slide, I think, is thank you. So thank you very much, and I would appreciate all your comments and feedback. Thank you so much.
Thank you so much, Isioma, for that wonderful, excellent presentation. You have done very well. It was very clear, and it's a very important and timely discussion. especially as we think of access to pharmaceuticals. I will now move on to our first discussant, who has also joined us. But now I would like to welcome Professor Adebambo Adewopo to please give remarks for 5 minutes. Then we can move on. So, Professor Adewopo, the floor is yours. Thank you.
I have very high regards for this process. However, it is my pleasure to contribute to this important forum out of respect to the academic process of your esteemed institution, notwithstanding that I'm right in the middle of another meeting. I will also congratulate my very dear sister for this very brilliant adventure in a very important area. And let me quickly start by saying that the entire IP and the public health debate has not only remained ever topical in both policy and academic inquiries such as this, it has not come into a full circle as the global pharmaceutical industry, the healthcare system, and the global IP system continue to converge and grapple with the effect of persistent global health emergency that we have seen in the last century. So this has made this work evergreen, very fresh, very bold, very courageous, very original, and indeed we add to the existing literature that is in that field. Having said that, the public health, pharmaceutical innovation, and access to medicine, including vaccines, have always raised important questions, some of which has been really, I was listening attentively to Isioma because I was not privileged to actually go through the details that was sent to me. Questions concerning the global IP rules and their implementation at regional, sub-regional, and national levels, especially as it concerns developing countries such as Nigeria with low pharmaceutical manufacturing capacity. And I want to emphasize that last phrase, that last word, for the attention of Isioma. I mean, countries such as Nigeria with very low pharmaceutical manufacturing capacity, because that's the big elephant in the house. And as you will see very shortly in my very brief remark, these questions are complex and interwoven. First, the dilemma, as Isioma put it, which correctly so, the dilemma of these countries in the interaction of the global patent obligations with local realities, consisting in the existing national patent law or regimes. Second, the tension between private rights and public interest. These are very important questions, which, of course, this remark cannot go into detail. And, of course, the broader IP development narrative or conundrum, if you allow me to use that word, as it affects the global south, remains germane in the global health debate. National governments have continued to face the challenge of employing TRIPS flexibilities and other measures, including the recent TRIPS waiver debate, to facilitate access to pharmaceutical products such as drugs, vaccines, diagnostics, and related technologies. And as I've said, the questions have remained on how to achieve adequate and affordable access to medicine in the public health system. Now, I agree entirely with all the initiatives and the proposals that I have listened to, such as reforming the existing patent systems of Nigeria and, of course, other similar countries. Very critical. Nigeria is right in the middle of reforming its entire IP law. We have just succeeded in reforming the IP, the copyright sector in the new Copyright Act of 2022. The public itself, the Nigerian public health system is also currently undergoing drastic reforms in terms of revamping the existing health infrastructures, health financing, and the rest of them. Then, of course, the issue of a more informed use of compulsory license and government use, as we have in the patent law of Nigeria. A more informed use of this framework, because we have a comprehensive framework for compulsory license and government use in the Patent Act of Nigeria, even though it's fairly old. Then, of course, I cannot agree anymore with Isioma with maximizing the existing regional frameworks, to promote the to improve the existing innovation ecosystem in our country and in our region. But again, in defining and aligning the TRIPS objectives, coming back to the TRIPS, in defining and aligning the TRIPS objectives with the promotion of public health, successive global rules through the TRIPS in revisions have always attempted to promote access to medicine. We see this in Doha, almost endless extension of transition periods, and the recent TRIPS waiver. Given the continued and the current state of flux, can we really say that these measures, so to say, these alleviating measures have really produced the desired results in answering the question that Isioma has posed as the basis of our thesis in this work? Has it produced the desired results, or that the result that we desire can be found exclusively or in isolation of the existing global instruments such as TRIPS? Or even you can extend it to the new WIPO treaty, the new treaty that we all know, that the WIPO treaty on the IP and GR and associated frameworks, which addresses the interface between IP as a modest step towards inclusive IP system in the world. That can also be relevant. But the question remains whether these measures, these global measures, have produced the result that we desire, in which is access. Identified practical measures such as addressing the successive weak implementation of TRIPS flexibilities, national IP law and policy gaps, local research, innovation, and development capacity, exploring compulsory licensing and government use, provisions of which, all of which must be anchored, importantly, on improving the local manufacturing capacity. They should all converge and form the basis of a renewed engagement in addressing the Nigerian dilemma as ably presented by the presenter. I just want to end there without going further and taking much of your time. But I think this is it's a honor for me, and I really enjoyed this, and I'll be ready to engage with Isioma if I'm called upon in the course of our work. Thank you very much. Thank you very much.
Thank you so much, sir, for taking time to join us from your busy schedule, including the fact that today you have multiple meetings. And thank you for those incisive and insightful remarks. I'm sure Isioma has, and the rest of us have all taken away something. Now I will move to our second discussant, who is Dr. Adaji. Again, I had read Dr. Adaji's profile at the beginning. So I will just welcome Dr. Adaji to take the floor. Thank you.
First and foremost, I would like to acknowledge the presence of Professor Ewelukwa, who is one of the pioneers of IP scholarship in Nigeria. And Mr. Gabriele, nice to meet you. Your work on inclusive rights formed the basis of one of my recent research on where I advocated for inclusive intellectual property rights in Africa, particularly in the context of open science. And this was recently accepted for publication by the South African Journal for Bioethics and Law. So nice to meet you. And of course, it's such a great honor to be in your midst today on such an important discussion on the intersection of intellectual property and public health, a subject that is not only critical for Nigeria, but for so many developing countries that are striving to balance innovation and access to essential medicines. Of course, I would like to commend the presenter for such an insightful examination of Nigeria's struggle to balance her international obligations while striving or seeking to foster local pharmaceutical research and innovation. Well, this is a dilemma that demands urgent and proactive solutions, particularly as our vulnerabilities was brought to light during the due to the global health challenges, particularly in the context of the COVID-19 pandemic, when it became obvious that we have a weak system of production and distribution of pharmaceuticals. And yes, the TRIPS agreement have made various provisions for flexibilities. And of course, during the pandemic, there were calls that countries, developing countries, could rely on such flexibilities. But beyond such pandemics, we've known that in the past, most developing countries have not been bold enough, except for the likes of South Africa, to some extent Brazil and India, that have taken that bold step. Most developing countries have not been bold enough to, leverage the TRIPS flexibilities, and we know why. With the external pressure from patent owning multinational companies and other issues that or factors that the presenter identified, it's not surprising that countries like Nigeria have not been able to take advantage of the TRIPS flexibility. But notwithstanding, as argued by the presenter, there is a need to reform our patent law, our patent system, in order to take better advantage of these various flexibilities. Otherwise, we risk remaining at the mercy of the global supply chain, and which at the moment cannot really satisfy the need of the teeming population in Nigeria. So, of course, yes, there are so many insights in this regard, particularly with reference to the Kenya situation, reference to, the presenter also made reference to giving powers to the Ministry of Health or Minister of Health in order to enable him to grant compulsory licensing where the need arises. But of course, we also have to be cautious in this regard as we make these various recommendations, because when you talk about these various flexibilities, it is not just for the sake of health challenges alone. If you're now arguing that this right or power should be given to the Minister of Health, what if the need arises in other contexts beyond the health sector? Are we now going to be giving these various persons in charge of these various sectors the power to issue compulsory license? So I think we need to tread softly in that regard as you go on to make your recommendations. And yes, well, just on the final notes, because I want to be brief as possible, and I say this with some sort of bias. As you go on with your research, as you make these various recommendations, as you emphasize on the need for us to look internally, while striving to balance, why Nigeria strives to balance the international obligation with public health priorities, you may also want to bear in mind the fact that Nigeria does not necessarily have to base its whole local pharmaceutical system on a patent-based innovation system. In this regard, you might also want to look at other aspects or emerging concepts like the open science concept, and also promote, like you have also suggested in your presentation, South-South collaboration or collaboration at the regional level, not just on the policy basis, but also with regards to research and collaboration. Because one of the challenges we have under the existing IP system or the existing globalized IP standard is a question of access. And these emerging initiatives like the Open Science Initiative are to promote access right from at the point of research to it also promote access with regards to the product themselves. Because when you talk about open science, for instance, the research is for public good. So it actually promotes access. And, these various initiatives are being promoted as alternative framework that to the existing intellectual property system. So the question of whether or not this goes against existing international obligation do not arise. In other words, these policies also provide a platform or framework within which a country can strike a balance between its international patent obligations and the need to promote its public health interests. Thank you very much.
Thank you so much, Dr. Adaji, for that very useful and constructive feedback. I'm sure, Isioma, you'll agree with me that it will really give you a lot to think about. Both discussants have really done an excellent job in commenting on your work. Please, for everybody, please feel free to use the chat to put any other comments or any other questions that you may have for Isioma, including things that perhaps she could think about as she continues to develop her project. But due to time, I will move on to welcome Gabriele, who's also joined us. I will just welcome you for 5 minutes before we then conclude the session. Thank you.
Thank you very much. Thank you. I will definitely be briefer than 5 minutes because I don't want to take much time for other questions and also feedback that Isioma could receive in this very interesting session. That I apologize again if I connected a little bit late, but I was in other meetings. So, but it's really good because I came in the most topical part, which was about the arguments and the methodology of the PhD, which is always, I know it's kind of difficult to frame those, but I think it's good to have them already in mind. And in terms of an advice and in general, an observation on this topic, which is extremely important as thankfully, Dr. Adaji remembered I wrote on this topic, and I think it's really important that we bring attention to this, not only from the perspective of Europe and US and the global north, but especially from the global south. And about that, it could be interesting, again, just to echo what Dr. Adaji was saying before, that you might look and explore some forms of management of knowledge, of resources, because that's what IP does. It manages knowledge. Patents manage a certain type of knowledge through a certain instrument, which is patents. But there are nowadays many instruments that are not formally recognized as IP, that they do even probably better than patents themselves. And I'm talking about knowledge commons, digital commons, and open source instruments, because and this is very important. I think we should look at these instruments not as basically only saying let's release everything into the public domain without any form of control, any form of enforcement, because that's what the risk is if you release everything in the public domain, right? You get something that is uncontrollable, unenforceable in a way. If you look at some instruments, for example, public-private partnerships or enforcement measures that are not entirely related on IP protection, you can find something that is still a form of enforcement, but it's less controlled by patents, and it's less restrictive in this way. And this is probably what the Global South needs right now. I make an argument that I say that the Global South, I think, is going through something that in Europe, in the US, we've been probably 50 years ago to ensure that the IP strategy is advanced. But probably we should start thinking about that we don't need an IP strategy, or at least we need an IP strategy that is balanced by something else that can be, again, commons, for example, or other forms of protection that are not as restrictive or as patents, because we need innovation on one side, but we also need involvement, inclusion, especially in those delicate subjects, delicate fields of science like pharmaceuticals, where there needs to be access to medicines, and there needs to be local production of these medicines, because the importation and exportation sometimes gets complicated. So again, this is a very general comment for me, to just focus not only on the law as it is, which is correct, treats patent legislations, which will be super interesting to read of, because, for example, I don't know much about the patent legislation in Nigeria or in other African countries, so that would be super interesting to find out about, but also focusing on some public-private partnerships that are actually developing in Africa, a few of them, but also around the world. So that could be another piece of doctrinal analysis that you can include, I think, in your work. And I would be fascinated to read it in the future, because again, we need more of these, especially from a perspective that's finally is not a European or a US oriented or Western perspective, but it's a perspective that includes different realities. And try to think about that. A patent system, even if we assume that the patent system ultimately is the answer, is the only answer available, try to think about maybe an approach to patentability that is tailored according to the needs of certain countries in certain industries. Again, very difficult to implement, something that has been only only in theory so far, but could be something to explore, like in terms of literature review and this stuff. So that could be another point. I know it's a lot of things throwing. It happened the same with me when I was presenting my when I've been presenting my PhD. There are things coming to me, but I think it's important that we should have a 360 degrees angle on these topics, because again, they need some answers, and also as fast as possible, possibly. Not to put pressure on your PhD or the end of your PhD, but just to give an idea of the urgency of the topic. Thank you very much. Thank you.
Thank you so much, Gabriele. You've given us all very good things to think about, and I'm sure Isioma as well, you'll take on board the feedback. We are coming now to the end of our time together, but I really wanted to give Isioma the last word, just within 1 or 2 minutes before we wrap up. Maybe you can reflect on what feedback you have received. Of course, you might not be able to reflect on everything now, but I'm sure you are noting it down. But perhaps you can just say 1 or 2 things, just to have the last word before I conclude. Thank you.
Thank you so much. I am just so, blown away with everything, and I am really full of gratitude to everyone that has contributed. It has really shaped my thinking. Like I was explaining to Dr. Norman, that sometimes, PhD can feel so isolated. You're on your own thinking of a lot of things, but you don't know if you're thinking in the right direction, or if you're just up in your head. So I really appreciate all the perspectives that have really been thrown my way. Yes, like Gabriele said, sometimes can seem like a lot, but it's actually very, very helpful and very beneficial. I really appreciate everything. I just want to thank Professor Ewelukwa. I will call him like I won't call him my mentor. I'll say he's like my grand mentor. I'll say, because he's a mentor to my mentors, because I'm too small when it comes to his caliber of person. So I just want to thank him so much for coming on here and just bringing all that his experience and his knowledge to bear. I'm just so grateful. Thank you so much, Dr. Adaji. You're just an amazing academic, and I really appreciate your perspective. I got so much from it, also particularly with the angle of that recommendation about the Minister of Health. I really appreciate that perspective, and I will look more into it, whether there's a way to even broaden that proposal a bit, or make more practical sense, I would say. So thank you so much for that perspective, and also with regards to looking at things from other angles, not only limiting to patents, because like I said, when I was coming in, a lot of people said, oh, why patent is useless. But I was feeling, okay, why don't we look for something within that patent? We can't just throw the document away. We still have the TRIPS agreement, we still have this internal law? How can we just still bring out something, no matter how little, but just make it work for our local system? So that was what I was trying to think about. But of course, we need to look at it more broadly. So I really appreciate that perspective, getting me to think more broadly, like not limiting to only patents. It still applies to patents, yes, but still bringing that broad perspective and saying, okay, how can even if reforming the Patent Act, how can we reform it in line with those broader perspectives, the Open Science Initiative and those other initiatives, just bringing them all together, and making it work within that ecosystem. So I appreciate that perspective. And Gabriele, I'm so grateful for your contribution. I really appreciate how you're able to broaden my mind, like you said, like this is what we need actually in the global south, to have that, and we want it to be from us, because there was one of these forums I attended, and they were talking about Africa, and I was saying, but there's no African in the room here. Why are we talking about solutions for Africa? So I was saying that I'm the only African in here. It shouldn't be. We should be the ones talking about what works for us or what should help us. It shouldn't be foreign. So that is really why I decided that this is something that we need to really look at. A lot of times when you're talking about solutions, they'll say, the TRIPS agreement, these are all still external solutions we are the ones that know how it can actually work. And really, that is why when they say the TRIPS flexibilities, that is why so far it hasn't really worked, because we're not the ones proposing the solution. So I really appreciate that perspective, and I will look into all that you have said. We can look outside, have that 360 view and say, look, this is our problem, and we are the ones that have what it takes to solve it. So I would definitely take on board everything that you have said and everything everyone has said. I really appreciate. Once again, Dr. Norman, thank you so much for this honor and privilege to be here. This opportunity, this platform is just really amazing. That's really helped me. Dr. Norman actually dragged me from the PGR room because he was always seeing me there with my head buried in my books, and I probably would have still been doing that, and just produced something that they will just keep on the shelves and say, this doesn't work. Okay, for purposes of academics, we leave it there, and which is not what I wanted to do. So I really appreciate this platform and for pulling me out of that space. Thank you so much, Dr. Beth, for coordinating this so wonderfully well, and helping me to keep the time and make it really worthwhile. So I really appreciate everyone. Thank you so much. Thank you so much. Thank you.
Thank you, Isioma, for those wonderful words and for your reflection on the feedback that you have received. So once again, I would like to thank our speaker, Isioma, for the wonderful, excellent presentation. I would like to thank our discussants, Professor Adeopo and Dr. Adaji. Thank you so much for honoring our invitation and for the amazing insights that you brought. I would also like to thank our peer commentator, Gabriele. Again, thank you for just the insightful and careful and thoughtful comments that you brought to the work. Perhaps, Isioma, you could also put your email on the chat in case other people maybe think of something later that they want to ask you or they want to engage with you. Perhaps you could do that. So just to wrap up, just to remind you that the Global South Network warmly welcomes PhD students from any discipline and any part of the world to share their projects, and receive interdisciplinary feedback. So anyone who is interested in presenting their work or participating in the session as a peer commentator, as a chair or a discussant, please contact Dr. Norman Rayad, who is on the call and who is the founder of the Global South Network, and the email will also be provided in the chat box. Next week, 5th February 2025, same time, 3 p.m. to 4 p.m., we will be joined by Ryuju Gu, who is a PhD candidate at the Leicester Law School. And they'll be presenting on a project titled Letter of Credit in the UK and China Comparisons. So we hope to see you all at some point in the future. Thank you so much for joining us and have a wonderful day. Bye.